Mr. Simpson is present before the court with you as counsel. Mr. Shapiro, Mr. Cochran, Mr. Ullman, Mr. Blazier, Mr. Neufeld, people represented by Ms. Clark, Mr. Goldberg, Mr. Darden. Jury is not present, and the jury is up in the holding lounge upstairs. And I recollect that I saw Michele Kestler this morning come in with a city attorney. All right. All right, Mr. Cochran.
Good morning, Judge Ito.
Good morning, sir.
Your Honor, one matter I wanted to bring to the Court's attention to perhaps get some clarification. Yesterday, the Court asked Ms. Clark whether or not she could establish a foundation, as I recall it, for some alleged videos of our client with gloves, which we had seen in the past. And Ms. Clark smiled at Your Honor and said, absolutely. And we were informed that yesterday, after court, Suzanne Childs of the District Attorney's Office called various members of the media that said Ms. Clark had been misquoted or had been misunderstood regarding their ability to lay a foundation regarding these items. And as officers of the court, I'm just rising to try to get a clarification of what is true and what was meant by what Ms. Clark said. If there's some misunderstanding, we have a right to know that, and we want to know exactly, and you have a right, obviously, to know what was meant. If they're backing off, you read the LA Times today, you'll see some mention of that, I think. And I know that's, forgive me, I forgot who I was talking to. You have not read the LA Times, right? But anyway, Your Honor, I think
no,
this...
it's not out of disrespect for the LA Times, but I found that it's not helpful for me to read news media reports of this case because I don't want to be influenced by any of them.
And I understand, Your Honor, certainly. I think we share that view on occasion ourselves. Your Honor, but at any rate, I rise to ask for clarification of whether Ms. Clark is saying she can lay a foundation that these gloves were similar, or these the exact same gloves. The information we got, and much of the media got, well, these were going to be the same gloves, and we know that's not true, so I think we should have some clarification of that, and I want to do that early on.
All right. Good morning, Ms. Clark.
Good morning, Your Honor. I don't try my case in the press, and I don't read the papers to see how I should respond to counsel in court. I think it was very clear to the court what was meant, what I said, and I think that's all that matters. What the LA Times thinks about what I said or any other reporter is irrelevant to me. The court understood me. The court questioned us at sidebar. I don't think there's any misunderstanding between the court and myself or counsel, and I don't think any further clarification is required.
We did discuss this matter twice, once in open court and once at the sidebar. And at the sidebar, my recollection is that we discussed the nature of the stitching and a few other...
Well, if I might...
And may I add one more thing? Yeah, just a minute.
Yes.
Sure. One more thing is that whether or not counsel puts in the glove drying experiment, the people's position is that those gloves and those photographs photographs of Mr. Simpson wearing those gloves will be relevant on rebuttal regardless of what the defense does with respect to experiments or not, because they are relevant to disprove the conspiracy theory. There are many reasons why those glove photographs will come in rebuttal, we believe, regardless of whether or not they come in during the defense case. This was simply one chance to put them in during the defense case. There may be others, but if there are not, on rebuttal to refute the conspiracy theme and to refute the planting theme that the defense has throughout carried in this case, I think
so
they are.
I take it the bottom line, Ms. Clark, is that you stand by your statements on the record of yesterday.
Yes, Your Honor,
right.
I do.
Well, that's fine then, because the only thing I want to point out, when Suzanne Childs, who represents that office, makes calls saying she was misquoted, I think we have a right to inquire upon that, and that's all we've done, Your Honor.
Okay.
We vigorously dispute that. They will never be able to prove these gloves, that our client wore those gloves, and you'll see. And then the last thing I'd like to say is that we've opened no doors on this. If they had this information, Judge, they would have put it in their case in chief. They didn't, and we'll vigorously oppose any attempt and rebuttal at that time.
All right, and just for counsel's information, late yesterday I received from the FBI a package of photographs and videotapes regarding shoes and gloves that my staff is cataloging right now and will make available to you later this morning.
Thank you.
All right, let's proceed to the Michele Kestler issue. My understanding is the defendant wishes to call Ms. Kestler to testify first to the normal things, that she's the lab director, that she did participate in the inventorying of some of the all of the evidence that was in possession of the LAPD at a certain point in time, did other things with regards to the physical evidence itself, and then there are the other issues regarding leaks of information. All right, so those two general areas, I understand, is what we're going to inquire into. Is that correct? Mr. Neufeld, are you going to handle this?
Yes, Your Honor. I don't even intend to spend that much time on her inventorying and things like that. I'm going to focus much more on access to information, what the security system was at LAPD for handling the information in this case, and what her role was in that, and how that relates to the leaks. I'm going to make it, I think, even more focused.
All right, well, this is a 402 hearing.
Right.
All right. And I understand we have counsel from the City Attorney's Office.
Yes, good morning, Your Honor. Herbert, Walsh, Assistant City Attorney, here on behalf of Ms. Kestler.
All right, Mr. Walsh, have you had the opportunity to consult with defense counsel regarding their reasons for asking for this 402 hearing this morning?
No, Your Honor, I have not.
All right. Do you have any comment, or have you discussed this with the District Attorney's Office?
I understand, both from talking to the District Attorney and from general press reports, what the scope of this is intended to be. And I, at present, have no objection to questions directed to the witness regarding her own personal knowledge of these matters. However, should questions intrude into her knowledge of any internal affairs investigation or any matter relating to personnel records of police department employees, I will make appropriate objections at that time.
All right, then the court will note your presence for the record, and you may rise to assert any objections at a time you feel appropriate.
Thank you, Your Honor.
All right. And Ms. Kestler, what are your time constraints this morning?
I need to leave by 10.
Okay, well, let's get started.
Your Honor, for the record, as the court knows, we did object to this procedure, given that there's no offer of proof. And in a 402 hearing, you do not necessarily have to call live witnesses, since it's merely a pretrial ruling of how the court would later rule at the trial itself.
All right. Your objection's noted for the record. Thank you.
Your Honor, Ms. Kessler says she has to leave by, what time did she say? I missed
10 o'clock.
10 o'clock. Thank you.
All right. Mrs. Robertson.
Please solemnly swear that the testimony you may give in the trial is not being before this court shall be the truth, the whole truth, and nothing but the truth, so help you God. Please have a seat on the witness stand and state your first and last names for the record.
Michele Kestler, Michele Kestler.
Mr. Neufeld.
Thank you. Good morning, Ms. Kessler.
Morning.
Ms. Kessler, what is your current title?
Currently, I am the Laboratory Director or Chief Forensic Chemist for the Los Angeles Police Department.
And as of June 12, 1994, what was your title?
As the Assistant Lab Director, or one of the Assistant Lab Directors for the Los Angeles Police Department Crime Laboratory.
And when did your title change?
Sometime in July, I don't recall the date.
Sometime in July of 1994?
That's correct.
Now, as the laboratory director, do you have, and before that as the assistant laboratory director, do you have some day-to-day management responsibilities for the various units within the SID?
Yes, I do.
And during that time period frame from June of 1994 to the present, was it also your practice to, on occasion, take responsibility for managing some of the larger cases?
Manager, more oversee, not necessarily manage, oversee and stay involved and help cause them to proceed at a somewhat normal pace as opposed to helter-skelter.
Okay, and in this particular case, did you play a role in overseeing the processing and handling of this case?
I was attempting to assist in that process because at that time, Mr. Matheson, there was no other assistant lab director, so I played a little larger role than I normally would.
Well, for instance, you were contacted by the police as early as June 13th at your home to be informed about what was going on. Isn't that right?
Just to tell me that a large case had taken place.
And you had meetings shortly after that on June 15th with Marcia and other people about the processing and handling of evidence, didn't you?
This is not relevant to the 402 issues, Your Honor.
It's not real relevant, counsel. We're talking about September issues.
All right. Well, Ms. Kestler, this case was given a special designation of a confidential case, was it not?
Yes.
Okay. And as a confidential case, are certain different procedures set up to maintain security of the testing of evidence and for the results of the testing of evidence?
The testing of evidence, and not sure I understand your question. I can answer half, and then I'm not sure that's
All right.
answering all of it. As for the testing of evidence, no, the testing is still done under the same process.
All right. What about the dissemination of test results and information? Is it shared differently in a case once it's been designated confidential?
Well, we normally, the laboratory only shares the results with the investigating officers and with the prosecutorial agency. That doesn't change either, other than the results are held in a separate secured area, usually a supervisor's office, file cabinet, someplace, until such time as it's over.
And in this case, is that the procedure that was utilized?
Yes.
Now, when you say that the test results are shared only with certain select people, in this particular case, who were those people, first of all, at SID, with whom the test results would be shared with?
All right, why don't we rephrase that question because it's vague.
Okay.
We're talking about a certain set of test results here.
All right, let me back up one step. All right. Were you also designated as the laboratory director to be the point person at SID, to be the recipient of reports governing test results in this case that were mailed to SID from outside agencies?
That is, I'm always the point person for all test results, only because they are addressed to me so that they don't go to the bomb squad or some other portion of SID who would know not what to do with them.
For instance, you had test results mailed to you, in this case, from the Federal Bureau of Investigation. Is that right?
Well, it's vague as to whether she physically received these or they were just addressed to her.
Rephrase the question.
Were the results that came from the FBI addressed to you, Michele Kestler, at the SID laboratory?
It's unclear to me. I don't recall whether we actually received them directly in the laboratory or whether they went to the court at that time. I've forgotten.
Let me just see if this refreshes your recollection.
Counsel, I'm going to sustain the court's own objection. I'm not interested in this.
I think, Your Honor, it's going to become very, very relevant in about 5 minutes.
Nope. We're talking Cellmark here, and we're not talking FBI.
All right, I can even explain it in front of, there's no problem, Your Honor. The issue is that at the same time that the report was received from Cellmark, they also received a report from the FBI regarding the hair and fiber analysis.
It's irrelevant.
Which was also leaked to the press the same day.
It's irrelevant.
Okay.
The only thing I'm interested in is whether or not
All right.
the Cellmark results.
Fine. All right. Have you seen a report from Cellmark Laboratory dated September 8th, 1994, that was faxed to Michele Kestler at the SID laboratory on September 12th, 1994?
Objection vague at the time.
Oh,
I saw a report dated September 8th, a hard copy of that report, that it sometime was faxed, but it was not faxed to me. It's addressed to me. I do not know what the cover fax, who the fax was sent to, or when.
You don't know to whom this was faxed?
No, again, my name is on the header, but I don't know what the fax cover sheet would have said, nor did I ever see it.
Your Honor, at this time, I would like to introduce, for the record, for the court's consideration of these issues, a 1, 2, 3, 4, 5-page report from Cellmark, which is a report dated September 8th, supplying results of DNA testing on the Bundy drops, with a fax from Cellmark of September 12, 1994.
And does this document have the imprint of the number that it was faxed to?
No, it has just the imprint that it was where it was faxed from, that I see on this particular sheet. The copy that we were provided by the prosecution in discovery says where it was faxed from on September 12th, 1994. It's addressed to Michele Kestler at the Los Angeles Police Department. What we also have in conjunction with this, which we received in discovery, and I'd like to introduce it at the same time, because it came at the same time as part of the same discovery, was a cover sheet from the Los Angeles Police Department Scientific Investigation Division of a fax from Michele Kestler to Marcia Clark at the Los Angeles County District Attorney's Office, dated September 16, 1994. In other words, we only received a copy that the District Attorney received.
Mrs. Robertson, what is the next in order for defense exhibits? All right, the Cellmark report of dated September 8th, addressed to Ms. Kestler, will be 1281, and 1282 will be the fax of Ms. Kestler to Ms. Clark.
Your Honor, I wonder if I might have the opportunity to review these. I haven't seen them.
All right, Mrs. Robertson, would you have the staff make copies for everybody, please? It would speed things up in the future if you're going to use documents that we have multiple copies available.
I apologize, Your Honor.
All right. All right, proceed, counsel.
Well, I want to just show her a copy of that document to see if it refreshes her recollection as to a report that she did, in fact, see from Cellmark Diagnostics. But
well, she's testified she saw it.
okay, all right.
She's familiar with what the report is. The issue is, when did she get it and when did she see it?
Michele Kestler, you were at the office at certain points in time on September 12, 1994. Isn't that correct?
That's correct.
And you said that given the fact that this was a confidential case, only certain people at SID were given access to reports, or to this report, if you will. Is that correct?
That misstates the testimony, Your Honor.
Roll. Counsel, Mr. Walsh, I'm going to allow you to make objections concerning the scope. However, the prosecution is the real party in interest, and if they choose not to make evidentiary objections, that's their choice.
Thank you, Your Honor.
Could you repeat the question?
Sure. Given the fact that this was a confidential case, who at SID did you authorize to have access to the Cellmark report dated September 8th that was faxed to your office on September the 12th?
Assumes facts not in evidence that she made such authorization.
Overruled.
I didn't know the report was coming, so I would have given no such authorization.
Well, prior to this report coming, since you said this case had already been classified as a, had already been characterized as a classified case, had a decision,
Sustained. Rephrase the question. Confidential case.
I'm sorry, what?
Confidential case.
Oh, confidential, I'm sorry, thank you. Since this case had already been characterized as a confidential case, what policy was in effect as to who at SID would have access to the reports that came from Cellmark?
Anyone that was involved with the serology aspects of the case, which at that time would have been off the top of my head, and like there could have been more because I don't remember who was doing what moment. Mr. Matheson, Mr. Yamauchi, and those are the only two that I can recall at the time,
And of course, yourself.
and myself.
And it was your practice to read the reports from Cellmark at some point after they were received, isn't that correct?
Not necessarily. Sometimes Greg Matheson would just fill me in on what it was.
Ms. Kestler, do you recall having a discussion with me and Barry Scheck at the office of the city attorney on July 13th of 1995?
Yes.
And at that time, during that meeting, didn't you say that you personally read every single Cellmark and DOJ report that came to the office?
No, I didn't say that.
Okay.
I said I looked at them if we got them, but we never got any DOJ reports.
Okay. So you said, in other words, that you did look at those reports that did come to the SID laboratory. Is that
Yeah,
right?
but I didn't read every single one word for word, no.
Okay. So it would be a fair statement that you did look at this report, which is dated September 8th, and that was faxed to the SID laboratory to Michele Kestler at some point.
At some point, I saw a copy of the fax.
Okay. I'm sorry. So you're saying that the only three people at SID who would have access to this report would be Colin Yamauchi, Gregory Matheson, and yourself. Is that right?
Misstates the testimony asked and answered.
Overruled.
Those are the only people. However, this report was faxed to someone. It was not faxed to me. I don't know who that individual is. So that individual would have to tell you who had access to that report.
Didn't you tell us on July 13th, Ms. Kestler, that the person who actually received the fax at the fax machine was Gregory Matheson?
I'm assuming that, but I don't know that personally. I don't have personal knowledge of that.
Did Gregory Matheson tell you at any time between September 12th, 1994 and today that he was the person who stood by the machine and personally received it?
Calls for hearsay.
It's a
Sustained.
402 hearing, Your Honor. I believe the court can consider hearsay.
Sustained. Rules of evidence still apply, Counsel.
As the head of this laboratory, do you know who it was who received a fax on September 12th, 1994 at the SID laboratory?
No foundation for personal knowledge. Calls for hearsay.
Overruled.
I have no personal knowledge of who received it.
As
All
the
right,
head
hold
of...
on, hold on. Where's the fax machine located in the laboratory?
It's in the internal offices outside my office. It would
Right.
be like back in your chambers.
So it's part of your office complex?
That's correct.
All right. And who is the SID person whose job it is to maintain the fax machine, to keep it full of paper?
Well, at that point, we had no one because I didn't have a secretary. So it was just the people within the offices.
Proceed.
Did you at any time, as the head of the laboratory, undertake to find out through an investigation who it was who personally received the fax on September 12th, 1994 from Cellmark Diagnostics?
Not relevant and calls for hearsay.
Overruled.
I can say that I was told by someone that they received it.
And who was that person?
Calls for hearsay, Your Honor.
Overruled.
Greg Matheson.
Motion to strike.
Overruled.
Now, you said that you named the people at SID who were given access to that report. You also said a little bit earlier that people in the investigating agency were also entitled to have access to that report. Did I misunderstand you?
I didn't say they had access to the report. I said that we would have told them what was in the report if they had asked.
All right. And who were the people at the investigating agency who would be entitled to be told what the substance of the report was, had they asked?
No foundation.
The lead investigators, Tom Lang, Phil Van Adder, and I suppose if Captain Gartland had ever asked for it, he would have gotten it, for example.
Where were these reports kept once they arrived? These reports, I'm referring now to Cellmark reports.
In Greg Matheson's office.
And where is Greg Matheson's office in relation to your office?
It's in the serology unit.
Well, is Greg Matheson's office still in the serology unit, or has it moved?
It's moved now.
He's in the same suite as you?
Yes,
Okay. And would they be locked up in Mr. Matheson's office?
yes.
Mr. Gold, I don't believe so. Mr. Robinson, is that fresh? No, let me get you a fresh one. Mr. Goldberg, does the prosecution have a copy of this particular report dated September the 8th that has the telephone number to which it was faxed?
No, my copy doesn't have a telephone number to which it was faxed, but it does have a number from which it was faxed.
All right.
So it appears to be similar to...
Ms. Kestler, do you know where the original September 8th report faxed report from Cellmark is?
No, I do not.
Actually, Your Honor, the people's copy is better than ours for one important reason. What it has on top of the line that shows the faxing from Cellmark, it has a line dated September 16th showing that this same copy was faxed from SID Piper Tech to the District Attorney's Office. So I think you probably would want a copy of their copy.
Although we already know that because that's on the facsimile transmission sheet.
I understand, but I'm just saying that every single page has that additional line which was not visible on our copies.
All right, proceed.
Can I simply just give this to
Well,
Deidre?
that's my only copy.
Well, no, I'm just going to ask you to make copies of it, if I may.
Let's not waste the court's time at this point to do that.
Fine. Now, Ms. Kestler, you learned, did you not, that some of the results reflected in that Cellmark report, which was faxed to SID on September 12th, appeared in newspaper articles on September 14th and September 15th of 1994. Do you know that?
Calls for hearsay.
Oh.
I know that at some time they appeared in newspaper articles. I don't know what day.
Well, not the exact date, but Ms. Kestler, you're aware of the fact that it appeared in newspaper articles during that same week of September 12th, 1994. Isn't that correct?
It also calls for a conclusion as to what was the source of the newspaper articles.
Sustained. Results is vague, counsel.
All right. Did you learn, Michele Kestler, that on September 15, 1994, the Los Angeles Times published an article in which it said that quote, final DNA tests in the O.J. Simpson murder case point to Simpson as the source of at least some of the blood drops found near the bodies of Nicole Brown Simpson and Ronald Lyle Goldman. Sources close to the case said Wednesday.
Calls for hearsay, no foundation for personal knowledge.
Overruled.
I'm not aware of that particular article. I just know there was some.
Ms. Kestler, when you were interviewed by Mr. Scheck and myself on July 13th, 1995, didn't you tell us that Mr. Matheson showed you this report after it was faxed to him, and that you were aware at about the same time that portions of the report had been leaked to the press? Didn't you tell us that on July 13th?
That's unintelligible.
Sustain. Rephrase the question.
Didn't you tell us on July 13th, 1995, Ms. Kestler, that you learned that week, within a couple of days after September 12th, that portions of that report had been leaked and appeared in the press?
Calls for hearsay.
Overruled.
I heard that some of the Cellmark results or some of the Cellmark work, which were also in that report, have been leaked to the press. I don't know if they came from that report or what their source was.
The motion to strike the witness's answer is calling for speculation.
Overruled.
Now, you also John, do you have the copy that was, this copy that's actually in evidence? All right. I'll show you, what number is it, Your Honor, that was marked?
Which, the Cellmark report?
Yes, with the cover fact sheet to Marcia Clark.
No, the cover fact sheet is only, is 1282.
Okay.
Has DNA discovery number 01728.
I'm going to show you, Ms. Kestler, defendants 1281 and 1282, and ask you to take a look at it. The fact sheet from LAPD SID of the Cellmark report to Marcia Clark at the DA's office on September 16th. Does it indicate on the cover sheet that you are the sender of this report?
My name is down there at the bottom, but that's not normally where I would put my name. This is not in my handwriting, so I don't recall directing someone to send it.
But it is your name that appears at the bottom of that cover sheet? And it's printed?
Yeah. No, it's handwritten.
Well, that's
and
what I mean. It's not part of the
oh, it's script.
typed form.
Right,
It's something that was written in.
right.
Thank you. And Ms. Kestler, when you learned that...
Excuse me, counsel. Do you know whose handwriting this is?
No, I don't recognize it.
Thank you. Proceed.
Ms. Kestler, when you learned that some of the results from Cellmark that are contained in the report that you received on September 12th and had not been sent out to the district attorney until September 16th appeared in newspaper accounts prior to the date that they were sent to Marcia Clark at the district attorney's office, did you, as the head of that laboratory, undertake any efforts to find out whether someone at SID was the source of that information?
Calls for conclusion as to the source of the newspaper accounts.
Overruled.
Well, I didn't feel we were the source, so I did no investigation. I presumed the leak had come from Cellmark. That was my assumption.
Motion to strike calls for speculation.
Overruled.
You said you didn't feel that you were the source of the leak. You meaning SID, I take. Is that right?
That's correct.
Okay. What was your basis for making that conclusion?
It's not relevant, Your Honor. Calls for speculation.
Overruled.
I just feel that our employees have too much integrity and honesty and have been involved in many, many cases before, and we have never been a source of any leaks.
Did you make any inquiry of the other two people who you said had the limited access to the Cellmark report as to whether or not they were the source of the leak.
It misstates the testimony that they were the only ones that had access.
Sustained. Phrase the question. Just use the specifics, Counsel.
Did you ask Colin Yamauchi whether he knew anything about how this information was leaked to the press?
Not relevant.
Overruled.
I don't believe I asked him specifically. I believe my question was, in general, to the individuals involved, had they disseminated this report already somehow?
When you say you made this inquiry to the individuals involved, first of all, which individuals are you referring to?
I'm assuming, because I don't recall, that it would be Greg and Colin, primarily. Probably Greg, and then Greg would have gone forth and asked the rest of the individuals.
A motion to strike is speculation.
Overruled.
And when did you have this inquiry of Greg Matheson?
I don't recall, right around the time of the leak.
Did you make any notes at all about your conversation with Mr. Matheson that you had with him around the time of this leak?
Your Honor,
No.
this whole subject is not relevant to the 402 hearing.
Overruled.
No, it wasn't important to me to do that.
Did you have more than one conversation with Greg Matheson about leak or leaks of DNA results in this case?
No,
Just this one conversation, you don't recall when or where it was?
no.
Other than a conversation with Gregory Matheson, did you conduct any investigation or inquiry or speak to any other individuals to try and ascertain the source of the leak?
No, I was convinced that it's not in the laboratory, so I wasn't concerned.
And other than based on a conversation with Greg Matheson and your own feelings, I guess you would have to characterize it, about the people who worked for you, is there anything else which was the basis for your conclusion that SID was not involved in this leak?
Your Honor, this is not relevant.
Overruled.
No.
Now, on September 20th of 1994, Gregory Matheson obtained PGM results on the socks in this case. You aware of that?
That misstates the testimony and evidence in the trial. I think it was the 18th.
Excuse me, Your Honor, at page
Overruled.
254.
Overruled.
Okay.
Are you aware of that?
I'm not aware on what date he got the results. It
Now,
was around that time.
Greg Matheson would report directly to you, is that correct?
He reports directly to me. Are you, in what context are you referring?
Well, generally speaking, first of all, in terms of the hierarchy of personnel at SID, would he report directly to you, or would there be anyone between Gregory Matheson and you?
He reports directly to me.
Okay. And you said that in this particular case, and correct me if I'm mistaken, that you would be kept informed by Greg Matheson as results came in dealing with analysis of evidence in this case. Is that correct?
Asked and answered.
Overruled.
Of anything significant, yes.
Okay. Well, would you agree that a PGM result on the socks conducted by Gregory Matheson in the serology laboratory, suggesting that the bloodstain was consistent with Nicole Simpson Brown, would be deemed, I'm sorry, with Nicole Brown Simpson, would be deemed significant in the case?
Yes.
Irrelevant.
Overruled.
And would it have been the practice in this case for Mr. Matheson to immediately report to you the results of this PGM testing on the socks shortly after he achieved those results?
Not necessarily immediately, but within a reasonable amount of time, depending on his schedule
Well,
and mine.
Greg Matheson's office is in the same laboratory as yours, is it not?
This is not particularly interesting, Counsel.
Had Mr. Matheson achieved the PGM results on the socks on September 20th, 1994, would he have presented those results to you shortly thereafter, without putting a specific hour on
For
it?
speculation.
Sustained.
Did you become aware of the PGM results that Mr. Matheson achieved on the socks from Mr. Matheson.
Yes.
Are you aware that on September 21st, one day after Gregory Matheson achieved the PGM results on the Sox, it was reported in KNBC that DNA typing on the socks had reached the conclusion that the blood on the socks was consistent with having come from Nicole Brown Simpson.
Assumes facts not in evidence.
Overruled.
Also calls for hearsay.
Overruled.
I believe it was the day after. I did hear it, and I think it was the day after.
The day after it was actually aired?
I believe it was the day after I found out. So that would have been the 21st.
Okay. The day after you found out about the PGM results, you mean?
Correct.
Okay. And so if you found out about the PGM results on September 20th, and you learned or you heard on the news this report by Tracy Savage on September 21st that there had been a DNA match on the socks between Nicole Brown Simpson and the blood found on the socks, did you at that point conduct any investigation to see whether or not somebody at SID had been the source of that leak?
Not relevant.
Overruled.
I personally did not conduct an investigation. I asked the same two individuals who knew and did anyone say anything, but I did not personally conduct an investigation.
So with regard to the sock leak, it's your testimony that you actually spoke to both Colin Yamauchi and Greg Matheson?
That's correct.
Did you speak to them together or separately?
I don't recall.
And when you spoke to Greg Matheson, did he tell you who, if anyone, did know about the PGM results?
Calls for hearsay.
Overruled.
He told me one other person in the laboratory knew about it, and as far as everyone else, I made the phone calls, so.
Motion to strike. No personal knowledge.
Overruled.
Who was the one person in the laboratory that Greg Matheson said had knowledge about the PGM results?
Calls for hearsay.
Overruled.
He felt that Aaron Riley knew about it.
So other than Greg Matheson and yourself, the only other person who had been told the PGM results at SID was Aaron Riley?
No, and Colin.
Okay. When you spoke to Colin Yamauchi, did you ask Colin Yamauchi any questions about who had access to the PGM results?
Well, no. The results, Mr. Matheson had the results. Colin didn't have the results.
Well, I'm sorry, and I apologize if I sound a little bit confused here. Did Colin Yamauchi know the PGM results on the socks at any time during September 20th or September 21st?
Sustained. Calls for speculation, counsel.
After Greg Matheson told you that Aaron Riley had also been told about the PGM results, did you have any inquiry of Aaron Riley?
Just that she knew about them.
Did you then talk to or meet with Aaron Riley to find out if she shared access to that data with any third party?
She indicated she had not.
Well, are you saying that you actually spoke with her?
Yes.
And when did that occur?
I don't know.
Did you make any notes of that meeting?
No.
Any notes of your discussions with Gregory Matheson about this leak?
No.
Based on your investigation, after you learned of the leak and the
Counsel,
Tracy Savage...
Counsel, I don't think it's appropriate to refer to it as a leak because it is misinformation. It is not a leak. A leak is something that is in fact correct.
Your Honor, in all due respect, I think there can be leaks of disinformation as well as leaks of information. This is something that this would not be the first time something like that happened in other situations.
I'm the one listening to this.
I appreciate that.
Proceed accordingly.
Based on your investigation, had the results of the
Assumes facts not in evidence conducted in an
Sustain. Rephrase the question.
based on whatever inquiries you made after learning the PGM results on September 20th and learning of Tracy Savage's report on KNBC on September 21st, had those results been given to anyone outside SID prior to the time that Tracy Savage aired her story on the news?
Yes.
And who had that information been given to?
The investigating officer, Tom Lang, and members of the district attorney's office, Marcia Clark, and I believe Lisa Kahn was in her office with her.
Were you the person who personally called the district attorney's office and gave them that information?
Yes, and Mr. Matheson was on another phone in the same room with me. Not a speaker phone, we were just on two separate phones.
Was that information given to Marcia Clark and Lisa Kahn on September 21st or September 20th?
I believe the afternoon of the 20th.
And you said that the information was also given to certain officers in the police department.
One officer.
And you said that was Detective Lang?
That's correct.
And when was that information given to Detective Lang?
It's afternoon of the 20th.
After your conversation with Ms. Clark?
I believe it was before.
And were you the person who also, was that done by telephone?
Yes.
And are you the person who actually communicated to Detective Lang the results of the PGM test?
Yes.
After learning of the Tracy Savage story, did you make any effort to find out whether individuals who you had given access to that information to, such as Detective Lang, provided access to that data to any third parties?
No, I would have no reason to inquire of them.
Did you share the PGM results that you obtained from Gregory Matheson with your husband, who's a detective at LAPD?
No.
Did you share the results of the September 8th report that was faxed to you on September 12th with your husband?
Well, number one, it wasn't faxed to me, even though I'm on the letterhead. It had to have a cover sheet, transmittal sheet. I never saw that fax till later. And secondly, no, I did not share it with my husband.
Well, when you say you never saw that fax until later, what do you mean, later that day or perhaps the next day?
Several days later, I think.
What is the basis for your belief that it was several days later?
Because at some point, someone asked me about the cell mark results, weren't they in? And I went and asked Greg whether we had gotten the cell mark results, and he said, yes, just a fax, and he showed me the fax.
Ms. Kestler, at the meeting you had with Mr. Scheck and myself on July 13th, 1995, didn't you tell us that you learned of the September 8th report shortly before you saw the results published in the newspaper?
Well, that could have been shortly before.
Okay.
I don't think that's when I saw it. I didn't see the results in the newspaper anyway, because I'm sorry, I don't read the LA Times. I listen to KFWB, so.
All right, but you said that it was shortly before you had learned that some of the results had been published in the newspaper. Is that correct?
Misstates testimony.
Around that time.
Okay, so had the results been published in the newspaper as early as September 15th, then you may have learned about those results as early as September 14th. Would that be fair to say?
That'd be fair.
Do you know who Commander David Gascon is?
Yes.
And who is he?
He's a commander with the Los Angeles Police Department.
And do you know what his particular role is at the Los Angeles Police Department?
Is he still a commander?
I believe he's moved up in
Is he a
life.
deputy chief now?
I believe he's a deputy chief.
Okay. At the time of this, in September of 1994, was he a commander then?
I believe he's still a commander at that time, and I believe he was in charge of press relations.
Okay. And had you had a professional relationship with David Gascon involving other cases in the past?
Very rarely I had spoken to him regarding other cases.
But you had spoken to him regarding other cases?
Not so much regarding cases. Oftentimes, press relations gives us the go-ahead to allow tours or allow press personnel to be interviewing us regarding other cases.
To your knowledge, does Commander Gascon friend of the reporter Tracy Savage? To your knowledge?
Sustained. Counsel, isn't the issue whether or not she shared any of this information with then Commander Gascon? Isn't that the issue?
Now, just so we can have a very good, clear sense of this chronology, Ms. Kestler, if the PGM results came in on September 20th and Tracy Savage ran her story on September 21st, isn't it true that the socks had not even been sent out yet for DNA testing as of September 21st, 1994?
Your Honor, it's argumentative, this phrased.
Oral.
It's also compound.
Oral.
I don't believe they'd been sent out as of the 21st.
In fact, wasn't there a meeting held on September 23rd at SID, at which time a decision was made to send the socks out for testing, for DNA testing?
My understanding was that, or my feeling was when speaking to Mr. Matheson on the 20th, that we were going to send them out for DNA. It was just a question of where and what testing, specifically what DNA testing would be done, and I don't recall the meeting you're referring to.
But you recall that there was some meeting held.
Your Honor, this isn't relevant.
Oral.
Let me just show you page.
Mr. Neufeld, you have 2 more minutes, so use your time accordingly.
Well, Ms. Kestler, other than any inquiries that you made, are you aware that there was an internal affairs investigation into the source of leaks of DNA reports in this case?
I'm aware only because I was interviewed.
And who interviewed you?
Calls for privileged information, Your Honor.
Who interviewed?
Yeah.
Yes.
Oral.
I believe his name, I hate to even suggest because I'm not sure I remember who it was. I could make a guess.
Okay, but approximately, don't guess, approximately when did this interview take place?
That's another one I can't remember. It seems to me it was in the fall sometime.
And to your knowledge, did internal affairs investigation conclude the investigation into this matter?
Objection calls for confidential information.
Sustained.
Was your interview by internal affairs into the leak issue transcribed, either with a tape, either by a reporter or by a tape recorder?
It was tape recorded.
One moment, Your Honor. Ms. Kestler, do you know Tracy Savage?
No,
You never met her?
no,
You ever spoken to her on the phone?
no.
Have you been the source of any information that have appeared in the newspapers or the press or television or radio about this case?
Absolutely not.
One moment. Did you give the information to David Gascon?
No.
Based on your own investigation as the head of the SID laboratory, Have you learned whether anyone else gave this information to David Gascon?
Ms. Cox not evidence that she conducted an
Sustained.
investigation.
One moment, Your Honor. Your Honor, I would ask that the witness provide at her earliest convenience, and I'll finish my examination now, with the name of the individual at SID who did examine her. And secondly, Your Honor, once we obtain the SID report, I would ask that she be allowed to be recalled, Internal Affairs report, that we be permitted to recall it to continue the examination.
You're not finished?
I'm finished with that one condition, that's all.
All right. All right, Ms. Kestler, if you would you make inquiry as to who the detective or sergeant was from IAD who interviewed you, and provide that information to Mr. Walsh? Mr. Walsh, will you provide that information to us, please? All right, Ms. Kestler, you're excused, subject to recall. Thank you very much.
Okay.
One question?
With respect to the September 8th, 1994 report that you've been questioned about, do you have a specific recollection today whether you first saw this before the news report, the day of the news report, or after the news report?
No, I don't have an absolute recollection.
All right, thank you, Ms. Kestler.
Thank you.
All right, we'll take a 10-minute recess, bring the jury down, and we'll conclude Professor MacDonell's testimony. All right, back on the record in the Simpson matter. All parties are again present. The jury is not present. Counsel, anything we need to take up before we invite the jurors to rejoin us?
Just one scheduling matter, Your Honor. I was contacted by Mr. Scheck. They filed a motion involving the contamination studies done by Dr. Gerdes.
Yes.
Could that be heard at 5 o'clock this afternoon? Or I think Dr. Gerdes is scheduled to testify tomorrow.
Are the lawyers available who are going to be arguing that issue? We may be able to get to it earlier than 5 o'clock today.
All right, well, fine, or 3 o'clock or 4 o'clock, whatever. But I would only ask that we do it after the Bosco matter, only because Mr. Scheck needs the time. So I would just ask that it be the last order of business.
All right, I think we can accommodate that this afternoon.
Because
Ms.
Mr.
Clark?
Scheck isn't here, that's all.
Is not here.
He's in Los Angeles, he's not in the building, and I'm just saying that that's why I'd like it to be at the end of the day.
All right. Ms. Clark?
May I make sure I believe Mr. Clark is here. I'd just like to make sure before I commit.
All right. All right, well, don't go away. I need to finish one other matter. There are two matters that the court had not resolved at the end of the day. Yesterday, there was the request for sanctions by the defense and an instruction to the jury regarding the dispute over Mr. MacDonell's notes regarding the examination that was conducted on April the 2nd. I'm going to instruct the jury as follows when they return. Quote, during the course of yesterday's cross-examination of Mr. MacDonell, it was suggested that Mr. MacDonell's notes concerning the examination he conducted on April the 2nd, 1995, had not been turned over to the prosecution. These notes were in fact turned over to the prosecution on July the 17th, 1995. You shall therefore disregard any negative inference implied by the suggestion. All right, as to the request for sanctions regarding violation of the court's direction that any use of transcripts, that a sidebar be requested before transcripts are used, the court reporters have not provided me with the transcript, and I lost it on my computer yesterday. So I will take that under advisement because I have not reviewed the transcript. All right, Deputy MacDonell, let's have the jurors, please.
Well, Mr. Goldberg, when we have our next break, we'd like to address the court. Whoever is here concerning the letter forwarded to the court. There were discovery violations by counsel that we had raised with the court that had not been resolved. And Mr. Goldberg forwarded the letter to the court concerning those violations. I don't know when the court, I think that perhaps before the jury is instructed, as the court proposes, that the court would need to hear from Mr. Goldberg about this because it does bear directly on the defense right.
No, the issue was whether or not the notes had been provided to you previously. This issue of sanctions for discovery is something completely different. It's a different subject. All right, let's have the jurors, please. Gentlemen, please be seated. And let the record reflect that we have been rejoined by all the members of our jury panel. Good morning, ladies and gentlemen. Ladies and gentlemen, during the course of yesterday's cross-examination of Mr. MacDonell, it was suggested that Mr. MacDonell's notes concerning the examination he conducted on April the 2nd, 1995, it was suggested that those notes had not been turned over to the prosecution. These notes had, in fact, been turned over to the prosecution on July the 17th, 1995. You shall therefore ignore the negative inference implied by that suggestion. All right, Mr. MacDonell, would you resume the witness stand, please? Mrs. Robertson, are we?
Yes.
Thank you. It's all right. All right, good morning again, Mr. MacDonell.
Morning.
Sir, you were reminded that you were still under oath, and Ms. Clark, you may conclude your cross-examination.
Thank you, Your Honor. Good morning, ladies and gentlemen. Good morning. Good morning, Mr. MacDonell.
Morning, Mrs. Clark.
Now, you stated, sir, that you were the director of a crime lab, correct?
That's correct.
And you still are?
Yes,
And that is the crime lab that you own and operate, is that correct, sir?
that's correct.
How's your commute?
I commute by going from the upper level to the lower level. We either have the laboratory in the lower level and live in the upper level of the laboratory, or the laboratory is in the lower level of the home, either way.
So your laboratory is in the lower level of your home, is that correct, sir?
That's correct.
And that's a profit-making business, isn't it? Hopefully.
It's supposed to be. Sometimes it isn't.
But isn't that where you derive most of your income, sir, from the laboratory?
Yes, directly or indirectly, yes.
And you have how many employees working for you, sir?
The current time I have one full-time, and other people come in from time to time as needed. I've had as many as 9 part-time people at one time.
But as far as regularly employed people that work for you on a full-time basis, it's 1, is that correct?
That's correct. Mr.
So on a
Kish.
full-time basis, the lab consists of yourself and 1 other person?
That's correct.
Now, sir, in your lab, do you have a dark room?
We have 2 dark rooms,
Two
yes.
dark rooms. You are an accomplished photographer, are you not, sir?
I would say yes. I taught forensic photography and had 2 photo studios, yeah.
And would you consider photography to be a key aspect of your job?
Absolutely.
And do you feel that that is a very important aspect of the talents that you have, sir, your ability to photograph forensically?
Well, it's extremely important to document certain things. Sometimes photographs are not needed, but it's certainly a very important asset to be able to take good photographs.
As a matter of fact, sir, when you don't take notes contemporaneously with an observation, if you do take photographs, that will document what you see. Isn't that correct?
Mostly it will, yes.
Now, in this particular case, sir, on April the 2nd, 1995, who was directing the photography of the sock?
Basically, Dr. Lee was, but we alternated. We looked at different areas in the microscope, and I believe he actually took the photographs, but we both saw what it was prior to it being photographed.
Now, in this case, you have told us about 6 or 7 of those little balls, only one of which was brought into court in the form of a photograph, correct?
That's correct.
You did not direct that any other photographs be taken of the other little balls, is that correct?
No, actually, I didn't know how many photographs Dr. Lee took. This is the one that I have seen most often, and I think it's an excellent photograph to show what we saw.
But you did not direct that the other little balls that you are now describing verbally to the jury be depicted in a photograph so that they could see it as well.
That is correct.
And in your judgment, sir, in your opinion, wouldn't it have been appropriate or a good idea to take pictures of all of those little balls so the jury could see them all?
I don't believe so. We've described them. They were there, and one that was representative and perhaps showed the bonding of the not only the red material that dried to a fiber, but the fiber being bonded to a thread. I think that was the best one that we could use as an example.
Nevertheless, sir, the 6 or 7 little balls that you've described is a key aspect of your testimony, wouldn't you agree?
No, I think that's just making the same point 6 or 7 times over.
You don't think that it would be important to let the jury see everything that you saw on April the 2nd, 1995?
Sustained.
Let me ask you this, sir. It was Dr. Lee that directed the photograph be taken that was brought into court of that little ball on the fiber?
Yes, collectively, we both looked at it, and he said this is one we should photograph, and he did.
In your judgment, sir, you are an expert in blood spatter analysis, are you not?
Interpretation.
Interpretation, excuse me. And in your judgment, sir, who is the more qualified expert in blood spatter analysis, yourself or Dr. Lee?
I think that's an unfair question. I would not rate Dr. Lee in any way. We have worked on many cases together and been on many seminars teaching the subject of blood-stain pattern interpretation. I've never given an examination, and he's never given me one. I'd say he's eminently qualified, and I'd like to believe I am.
Then would you say, sir, that you're both equally qualified?
I think that's a fair statement, yes.
Then wouldn't you say that you also had equal say in what photographs should be taken to depict the observations and document the observations that you made on April 2nd?
That is true.
And you did not direct that any additional photographs be taken than the one that was presented in court today of that one little ball?
That is correct.
Now, you did not write, when you said notes the other day that you had taken, those notes contain no description of the little balls that you have come here to testify to, is that correct?
That is correct.
Nor does the report you wrote on July 11th contain any description of the little balls that you have testified to here in court. Isn't that correct?
That is correct.
Now, if as a scientist, sir, you are supposed to document everything that you see contemporaneous with the observation, and photography is one way of doing that, wouldn't it have been very important, in view of the fact that you made no notes at the time of your observation, to take photographs of all of it, if only to refresh your own memory as to what you saw?
In this case, it wasn't necessary. I can remember those spots that I saw very distinctly, and I knew that photographs were being taken, and I could see no point in writing down a note that says, I'm looking at little red balls. I remember them very well.
Well, sir, isn't it true that in your report you wrote that the outer stain was a swipe, correct?
Correct.
And then,
Excuse me, yes, answered several times.
Overruled.
and then you testified, I believe, yesterday that you looked at photographs and based on your re-examination of the photographs determined that in fact it was a compression and so testified. Do you recall that, sir?
Yes, I do.
In that regard, then, sir, having had the photographs to review, you actually changed your opinion as to the appearance of a stain from swipe to compression. Isn't that true?
Objection, you've been over this several times yesterday.
Overruled. It's a new point, counsel.
I did not change my opinion. I changed my characterization. If you want to use swipe or compression, They're basically the same thing. The difference is a slight marginal variation, and that's all.
If the difference is a slight marginal variation, sir, why did you not say that during direct examination when you were making the point to the jury that, in your opinion, this was a compression
Sustained.
and not a...
Sustained.
Nevertheless, sir, your documentation of the appearance of the outer stain was what led you to make a different characterization of the appearance of that stain. Is that correct?
It's not a different characterization. It is simply an adjective. Adding swipe makes it a little bit more on one side than another. Depending upon which photograph I look at, I could use either term. There is really no difference between them as far as that particular stain is concerned. Either term you like, I will agree with.
Then you would agree at this point, sir, it could be a swipe, it could be a compression, and it really makes no difference. Is that your testimony?
That is correct.
Nevertheless, it was the presence and the use of the photographs that you took to document your observations at the time of the examination that caused you to take a step farther away from swipe and testify that it was compression, was it not?
No.
Then what was it, sir, that changed your mind from the time you wrote your report indicating it was a swipe to the time you testified and indicated on direct examination it was a compression?
It was the photograph Dr. Lee took.
The photograph Dr. Lee took. And there are no other photographs than the one to document your observation of the little balls than the one little ball you brought into court today, yesterday. Is that correct?
Overruled. Last question on this line, though.
That is correct.
Now, sir, if you and Dr. Lee are of equal stature in the field of blood spatter interpretation, what was your role there? Why do we need two? Why did you need to have two people present to examine the sock?
Sustained.
Can you tell us what your role was? Strike that. Dr. Lee, in your opinion, is as qualified as you are in blood spatter interpretation, correct?
Yes, I would say that.
And he was examining that sock under the microscope along with you, correct?
That's correct.
And he was directing what photographs should be taken. Is that correct?
We were deciding between ourselves which photographs should be taken. He merely took them.
Then can you tell us, sir, for what was your role in the examination on April 2nd, if the two of you were equally qualified looking at that same pair of socks?
Objection, argumentative, and irrelevant.
Overruled.
I was there at the request of attorneys to conduct an examination with Dr. Lee. I have no idea why they asked for two. They might have asked for three, but that is not something that I am privy to. I don't know why they asked for two.
All right, your lab, your work is not monitored by any independent agency, is that correct?
Not that I'm aware of, no.
And I think that, will you agree, sir, that the only check or balance for quality assurance on your work is that an opposing side may read your report of your conclusions and disagree?
Objection, argumentative.
Overruled.
Well, they may read my report, and they may disagree, or they may agree with me. They don't disagree by reading the report. That depends upon what they feel.
I'm sorry. Right. But the only check or balance for quality assurance that you have, sir, is when the other side reads your report. They may agree or disagree, but that's your check or balance, correct?
You could call it that, yes.
There are no validation studies administered to you by outside agencies, is that correct?
That's correct.
No blind studies are administered to your laboratory by another agency or organization, is that correct?
Not by other agencies, correct.
And unlike Cellmark, where they have in-house blind studies to test their quality control or the accuracy of their testing methods and results, you have no such blind...
Evidence
Overruled.
and argumentative.
Sustained. Rephrase the question.
Sir, have you heard testimony from representatives of Cellmark that they do conduct blind studies of their own testing procedures and methods to make sure that their quality control is kept up?
Objection, irrelevant, and also I...
Sustained.
Okay.
Do you have any blind studies that you conduct, sir, within your laboratory for purposes of quality control?
Yes.
And what is that blind study that you conduct?
I prepare samples, or we receive evidence, actual evidence, and Mr. Kish and I review it independently, and that would be, in my opinion, a blind test. If we agree, then we have conducted a verification of each other's ability to arrive at the same conclusion.
And if you disagree, do you publish the results, sir?
I can't remember when I've disagreed.
So you've always agreed with each other?
On evidence matters, interpreting bloodstain patterns, we discuss it, and we agree, yes.
And so if you always agree with each other, sir, it's only between the two of you working together, is that correct?
That's correct.
If you always agree, do you consider that to be a blind study that's a check on your quality control?
I sure do. I don't know what he's going to say, and he doesn't know what I'm going to say.
And
That's
nevertheless,
blind.
I'm sorry?
That's blind testing.
And if you should disagree, there is no record kept of that so anyone would know.
Objection, Your Honor, it's mere speculation.
Sustained. Rephrase the question.
You keep no records of the times you agree or disagree. Is that correct?
Objection, facts not in evidence, so we testify they didn't
Sustained.
disagree.
Counsel, you're getting close there. Proceed.
How many years have you been working with Mr. Kish, sir?
Well, actually, he works with me. I would say, I think 6 or 7, something like that. He's assisted me with many bloodstain institutes, so I could go back and see the first one he helped me with. I think it was about 6 or 7 years ago.
Is he on your payroll, sir?
Yes, he is.
And you pay his, is it a regular salary that you pay him, or is it case by case?
It varies. It's a regular salary, but because I'm letting him do more and more cases independent of myself in somewhat of semi-retirement, you might say, I really do not have any financial control over some of his cases. Some I do. If they come to me and I assign them to him and he works on them, then he receives a substantial amount of the fee.
Okay. So he's dependent on you for his livelihood. Is that correct, sir?
Yes.
And he's the one who is your check or balance as to whether or not you have made a correct interpretation or not. Is that right?
Yes, you could say that.
Is there any licensing required for your lab, sir?
No.
Or monitoring of your lab by an independent agency?
Not monitoring as such, but I was a member of the New York State Crime Laboratory Advisory Committee for many years, and there are 14 laboratories in New York State, of which my laboratory was one, and that was a discussion group more than certification or anything of that nature.
Right. Your lab is not certified by any agency. Is that correct?
That is correct.
And the group that you just spoke of does not monitor your lab for appropriate operating methods or procedures, does it?
No, it does not.
And there are no requirements that you personally be tested at any time to prove that you are using approved methods in your analysis of cases. Isn't that correct, sir?
Nothing other than cross-examination such as this.
And that would depend on how closely you're cross-examined. Is that correct?
How
Objection
detailed.
assumes the fact it's not in evidence.
Overruled.
How detailed, not closeness.
Okay, I'll agree with you. How detailed the cross-examination is that correct, sir?
Yes.
And if the cross-examiner knows virtually nothing about bloodstain pattern interpretation, then the cross-examination will not be very detailed at all. Wouldn't you agree?
Well, speculation is irrelevant.
Overruled.
Well, it's difficult to say how much an attorney knows about bloodstain pattern interpretation. I've had several attorneys attend the Institute, and I would like to think that those attorneys could do a very good job. As yet, I've never been cross-examined by one of my former students, so I really don't know, but the more they know, the better job they can do, and it helps me a great deal because they don't ask questions which might seem logical but are scientifically incorrect.
Nevertheless, sir, the degree to which you are tested by cross-examination, since that is the only means of your being tested for your current knowledge of the state of the art.
Objection, Your Honor, that's not his testimony.
Sustained. Rephrase the question.
You indicated that the only way by which you are tested to show that you are using approved methods or sound methods of analysis is by the nature of the cross-examination. Is that correct?
I would use the word challenged rather than tested, but yes, that is correct.
In which case, you are only as challenged as the cross-examiner is effective. Isn't that correct?
Or as they wish to be. They may decide not to ask many questions if they feel it will not be to their advantage. I can't read their minds.
All right, let's move on.
All right, now, if the other side, whatever side that may be, disagrees with your opinion or your conclusion, does that give you some indication, sir, that your view may be in error?
Sustained.
So do you believe that you can make mistakes?
Certainly.
And do you think that, have you ever drawn the conclusion that you have made a mistake based on the opposing side's disagreement with your conclusion?
No, that's not the kind of mistake I'm referring to.
Well, what kind of mistake are you referring to, sir?
And I made a mistake yesterday when I had the red eye last night. That's a mistake.
I'm sorry?
I couldn't get my airline reservation last night because I'm here today, and it was a mistake to tell my wife I would be home this morning at 10 o'clock. That was a mistake.
Well, sir, I'm talking about your work. Has it ever occurred that the other side has disagreed with your conclusion and that disagreement has caused you to re-examine your position and determine that you have made a mistake?
No.
And yet you have testified that the only check or balance, quality control, if you will, on your work is when the opposing side disagrees with you.
That is correct.
And yet when they do disagree with you, that does not cause you to re-examine your work and possibly conclude you made a mistake.
I've re-examined the things that they may have brought up and confirmed that, in my opinion, I was correct. I agree that anyone can disagree with me. That's their prerogative.
May we approach, Your Honor?
Yes, with the court reporter.
All right, Mr. MacDonell, you indicated, did you not, that you've been paid $10,500 for your work thus far?
That is correct.
And how much are you paid per day to testify?
Ordinarily, if I'm out of the laboratory for a day, overnight, I charge $3,000. But in a case of this type, where I have traveled so many times and been away from the laboratory so many hours, I cannot charge a rate like that. I really don't know how much time I will charge for. I do not charge on an hourly rate when I've spent this much time. I'll charge a fair rate for the amount of time and effort I've put into this case.
All right, you, as of April 2nd, 1995, had been paid $10,500. Is that correct?
Yes, that includes some travel expenses and my associate and other things. That's not just a basic profit, so to speak.
And that was up to the point of your examination of April 2nd, 1995, that you had been paid $10,500. Is that correct, sir?
I believe so, yes.
And since that time, have you submitted any further bills?
No, I haven't had time.
And you have done further work, though, nevertheless, have you not?
Yes, I have.
You have done several days' worth of work. Would that be fair to state?
Yes, and I have been here 3 times, I think, since then.
And you have been here for the purpose of your testimony how many days now?
I'd say it's maybe 10 days, 8 or 10 days, very close to that. I can look it up. I was here from the 7th to the 12th, the 16th to the 20th, the 25th to the 28th, and I'm here again. So that would be...
I'm sorry, sir, say that again. 7th to the 12th of July.
Oh, excuse me. That was another meeting. That was in Philadelphia. I came the 16th to the 20th. That would be 5 days, and the 25th to the 28th, 4 days, and I've been here 2 days, so that would be 11 days.
Right. And ordinarily, in the average case, you charge $3,000 a day.
That is correct.
So if you were to
No,
charge...
that's to stay overnight. That would be 2 days.
All right. And in this case, you have 11 days down, correct?
That's correct.
So if this were your average case, you would have charged... What is... 33... This is terrible. This is terrible. What is it? Okay, roughly $18,000 for your work thus far, if it had been the average case, correct?
No, it would have been several average.
Wait. Mr. Fairtlow, keep your voice down. If I can hear you, it's way too loud. Sustain. Rephrase the question.
If you were charging your average fee in the average case at $3,000 per day after 11 days being present, how much would that be?
Sustain. He said he's not going to bill on his normal schedule.
And how do you intend to bill, sir?
I'm not really sure. I must confess I've never had a case that has been of this type. I will be fair and not do anything that will cost more money. I've saved the defense considerable money by using golden opportunities air flight books at $300 a trip instead of the first 2 were $1,409 a ticket. I think I've saved them $3,300 on that alone. I'm not trying to make a profit, just a reasonable wage.
Your Honor, there'd be an objection. Motion to strike is non-responsive.
Overruled.
Mr. MacDonell, I'm tempted to ask you now what you intend to bill the defense. Can you answer that question, sir?
Not at this point.
Do you intend to bill them at 50% of your normal rate?
Objection. Asked and answered, Your Honor.
Overruled.
I really don't know. I've never had a case like this. I will be fair and charge them what I think the amount of time I've put in would have been had I been in my laboratory. I do not charge a rate every day because I don't spend 8 hours a day.
Mr. MacDonell, are you attempting to convey to this jury that you're not in this for the money?
Sustain. Sustain.
You do intend to make a profit on your work in this case, do you not?
I hope so, yes.
And since you have spent at least 11 days since April the 2nd of 1995, you do intend to make more money than the $10,500 you've already been paid. Isn't that correct?
I really don't know until I have sat down and assessed the time I've spent. I would say that is an approximation that might be accurate, but I do not wish to limit my bill by stating in court what I'm going to charge. I have done that before, and that's all the attorney would pay me, because under oath I said I'm going to charge $400 more, and it turned out to be $550 or something. They wouldn't pay me the extra $150. So that's why I say I'll be fair, but I don't want to commit myself to something and then find out I have to live with it and feel I didn't get a fair price.
All right. Do you feel that you will bill at least $10,000 more for the services you've rendered?
Objection, ask and answer.
Overruled.
As far as the amount of expenses go on top of what I have done, I would say that's approximately close.
To the minimum that you will bill?
No, it might exceed it. I don't know.
All right, let's move on.
Sir, you indicated that you are a New York State Crime Lab board member
I
for the
was.
advisory committee?
I was, yes.
And isn't it true, sir, that you last attended a meeting of that advisory committee in 1982?
That's probably right. They quit sending me the notices of the meeting, and so I couldn't go.
And you were not involved in quality control, isn't that correct?
That's correct.
Now, at this point, sir, with the one photograph of the one ball that you have shown us, at this point, all we have is your memory and your testimony to rely upon for the appearance of all the other little balls, the 6 or 7 that you've seen. Is that correct?
Objection, argumentative, and asked and answered on this subject 6 times.
Sustained.
May we approach, Your Honor?
Proceed.
No, I have not on a question. May we approach?
Yes. All right, thank you, counsel. Proceed.
At this point, in view of the fact that we have no photograph of the 6 or 7 other little balls, we have only your testimony to rely on. Is that correct, sir?
Objection, argumentative, asked and
Overruled.
answered.
Sustained.
I didn't get an answer last time. It was...
I sustain the objection, counsel.
Sir, is it your testimony that we rely on right now with respect to the appearance of how those other little balls looked? Your verbal description.
Overruled.
Objection, asked and answered.
That's a different question. You can answer the question.
Apparently so.
And, sir, you cannot say when those little balls got onto the, that inner surface before your examination on April 2nd, 1995. Isn't that true?
Objection,
is
asked
true.
and answered yesterday.
Overruled.
That's true.
And you cannot say that the compression stain that occurred on the outer surface of the sock was made at the same time that the little balls got onto the inner surface on the other opposite inner side?
I can put a limit on it, yes.
But you cannot say that they occurred at the same time, can you, sir?
No, they couldn't have occurred at the same time. One had to precede the other, if maybe by just a second or a fraction of a second. But the inside did not occur on surface 3, did not occur before 1 and 2.
And it didn't, and you cannot say exactly when it occurred after the outer compression stain was made. Isn't that correct, sir?
That's correct.
And you cannot even tell this jury that those little balls on the inner surface are associated with the outer compression stain. Isn't that correct?
I conclude that they were.
But you cannot tell this jury that they were absolutely associated with the same outer stain. Isn't that correct?
That is correct.
Now, sir, just with respect to the outer compression stain or swipe, either one that you say it now can be, you cannot exclude the possibility, can you, that the stain was made during the commission of the murder at Bundy. Isn't that correct?
Objection asked and answered yesterday.
Sustained. That question was asked yesterday.
So you cannot exclude the possibility then that that outer compression or swipe stain was made by making contact with the step covered with the blood of Nicole Brown. Isn't that correct?
Objection asked and answered.
Overruled.
That is correct.
And you cannot exclude the possibility that that outer compression or swipe stain on the sock was made at the time of the murder as the murderer stepped near the neck of Nicole Brown. Isn't that correct?
The neck, it's possible, yes, but I'd sooner think your example yesterday of a thumb or something that sticks out would be more likely. The neck would be too wide an area of blood staining to limit the transfer to that size stain. I mean, it might be possible, but I'd agree more with a thumb or something that sticks out.
Then you would agree, sir, that it would be more probable that it would be the thumb or bloody hand of Nicole Brown that could have come in contact with the sock to create that compression stain. Is that
Sustained.
correct?
Sustained. Speculation, counsel.
You cannot exclude that possibility, can you, sir?
Objection asked and answered yesterday.
Overruled.
And argument.
Sustained.
I cannot exclude it.
I'm sorry.
Wait.
Oh, I'm sorry.
Sustain the objection. It is speculation. Proceed.
Sir, can you exclude the possibility that the stain on the outer, that the outer stain that you call a compression or swipe could have been made by brushing up against the bloody hand of Nicole Brown?
Speculative and asked and answered.
That was asked yesterday. Sustained.
All right, sir, you were not present. We showed photographs yesterday of the phenol test done with that swab in the picture. Do you recall that?
Yes.
And we discussed the performance of that phenol test that uses distilled water to perform the test, correct?
You can use distilled water, yes.
And it was apparent to you from looking at the photograph of the sampling step that was being shown in that photograph that that was the method that was being used in that with the sock, correct?
Correct.
Objection asked and answered.
Overruled.
That's
Now-
correct.
All right. Now, that test, you were not present when it was conducted. Isn't that correct?
That's correct.
You do not know how much pressure was applied by the person swabbing the sock with that Q-tip, correct?
That's correct.
You do not know how much water was used in swabbing the sock with that Q-tip, correct?
I don't know how much they used. I know how much they should have used.
Okay, but you don't know how much they did use, do you?
That's correct.
And you don't know how large an area was swabbed, do you?
No, I don't.
And if the blood was difficult to see and that test was being conducted under normal lighting, in an effort to do a blood search with that swab, it could have been a very large area, could it not, sir?
Objection speculation.
Sustained.
Nevertheless, you
Excuse
do
me,
not know
just a
how
second.
large an area was.
Excuse me, counsel. If I hear the bases and I hear urgings for objections, and if I can hear it, the jury can hear it. Proceed.
Since you were not present then, sir, you cannot tell us how large an area was swabbed with that swab, correct?
I can state that it did not go to the edge of the stain itself because the blood is very clear, crisp, and sharp at the edge of the stain. Had a swab that was wet gone into that area, it would have diluted and diffused it, and it would not look as it does. So it would be confined more to the center than the periphery. That's the only limit I can put on it.
With that limitation, sir, but you cannot tell us what portion of the stain contributed the little balls you saw on surface 3, whether it was the periphery, the periphery or the center of the stain, can you?
Yes, I can eliminate the periphery because it did not soak through the fabric. Only the center area soaked through. So that's the only area that could have caused the staining on the third side.
And that's the only area where the phenol test was conducted, in your opinion, sir?
That's where they should have conducted it, where it's the most concentrated, yeah.
Well, didn't you just testify, sir, that based on your observation of the periphery of the stain, that the way it appeared, there was no water swabbed around that periphery that you saw?
Objection is the term water swab.
Sustain. Which misstates the evidence is what the correct objection is, counsel.
Sir, we discussed the performance of that phenol test using distilled water, correct?
Yes,
And in the sampling process, you would use a wet Q-tip to swab the area to see if there was something that appeared to be worth testing, correct?
yes,
And you were not present when that test was performed. We've already established that, correct?
correct.
So in the swabbing process with a wet Q-tip, using an amount of pressure you're not aware of, it's your opinion based on what you saw that the periphery was not sampled in that manner, that the center of the stain was sampled in that manner, correct?
Objection is the form of that question.
Overruled.
Yes, that's correct if it was very wet, the Q-tip.
And it is your opinion, sir, that the little balls on surface 3 came from that center part of the stain where you opine the swabbing was done.
It was done through the cutout, which is basically the center.
Which is where you opine the swabbing was done.
That's correct.
Did you test the little balls in any manner to determine whether or not, if they were blood, they were diluted in some manner?
The answer is yes to me.
Sustain. Correct. Re-ask the question.
Did you test the little balls in some fashion to determine whether, if they were blood, they were diluted?
I didn't do any testing. I did an observation, and they were deep red and did not appear to be diluted at all.
Nevertheless, sir, you did not test. Is that correct?
I don't know what test you could apply on something that small. I did not. I don't think anyone could.
So then you cannot tell this jury that whatever it was not diluted in some fashion, can you, sir?
Objection misstates his testimony.
Overruled.
I can conclude it wasn't, but I cannot say absolutely, one, that it is transferred from the outside, and if it were, it would be blood, and two, that it is not a concentration in some fashion, but I cannot conceive of how that could occur. It appears to be a fresh sample of a red fluid that is dried and bonded to a fiber.
Sir, isn't the basic tenet of science the cornerstone of it testing, sir?
I think it's observation and then
testing, is it not, sir?
Objection, he has to be allowed to finish his answer.
Sustain. Let him finish before you start the next question.
So it's observation and then testing. You have to observe something to determine what you might test for. I think it goes in that order.
Right, and it's based upon your observation, you form a hypothesis, do you not? Or a theory, do you not?
I formed a conclusion.
But then you go to test that conclusion to determine whether it is correct or not. Isn't that true, sir?
If it's possible to do so, you should, yes.
And is it not true, sir, that on occasion it will happen that you have a theory based on your observation that is disproven by testing? Doesn't that happen, sir?
Vague objection.
Overruled.
It could, yes.
And in this case, sir, you formed a conclusion based on your observation, which you could not test. Isn't that correct?
That is correct.
And so you cannot rule out the possibility that whatever you observed that substance was in those little balls was diluted or not. You cannot rule out the possibility that they were diluted, can you, sir?
Overruled.
I can't absolutely rule out anything in any instance, and in this case, I could not absolutely rule it out as a scientist.
Nevertheless, if you had tested those little balls in some fashion, you might have been able to. Isn't that
Sustained.
correct?
Sustained.
And, sir, you cannot rule out the possibility that those little balls were created at the time that the phenol test was conducted on August 4th. Isn't that true?
It could only be ruled out if the testing was done in the normal procedure, not using a saturated Q-tip. That is not what you use when you have a stain of that size. So if it was done properly, there would not be enough liquid to dissolve any blood and transfer it to the inner surface, surface 3, and if it was, it would not appear that red. That is my conclusion.
And what tests did you do to support that conclusion, sir?
There is no test you can do except observation with good optical equipment.
Sir, what experiments did you perform on the material of this sock to show that a phenol test using distilled water on a swab would not produce those little balls on the opposite inner side?
I didn't have the socks to experiment with. I didn't do that.
Did you make any attempt to experiment, as I've suggested, performing a phenol test on a blood stain to see if that would cause some seepage of microscopic quantities onto the opposite inner side?
Objection, no foundation.
Overruled.
Not on that sock.
Did you attempt to do it on any substance or material that was identical to or very similar to that sock?
Yes.
You did a phenol test and attempted to observe whether there were microscopic particles on the opposite inner side after you performed the test?
I didn't do a phenol test or a phenolphthalein test because I knew it was blood. I put it on the material myself.
And can you show us the documentation from the phenol test that you conducted with distilled water and a swab on material just like those socks?
Sustained. Sustained.
Sir, what experiment did you perform on material just like these socks to show that a phenol test on a blood stain on an outer surface that is just like this blood stain would leave the microbes or not leave those little balls on the opposite inner side?
I applied blood to a similar material, a stocking that was of the lightweight polyester composition, and brushed it on lightly, enough to soak through, and after that I cut out a portion and observed the side opposite corresponding to side 3.
No, objection. Objection, Your Honor. This is not my question. This is non-responsive.
Sustained.
Ask motion to strike.
Answer stricken.
Mr. MacDonell, please listen to my question. I am asking you now whether you took material just like these socks with blood on it, performed a sampling with a wet Q-tip, pressing down with that wet Q-tip to sample the blood, and then observed the opposite inner side after it had dried to see if there were little balls like those observed on this sock. Did you do that, sir?
Not that specific experiment, no.
Thank you, sir. And lastly, sir, you cannot rule out the possibility that those little balls that you observed are the result of someone with a bloody hand pulling off their socks, can you?
Objection, asked and answered yesterday.
Sustained.
You did? You did? I have nothing further.
Mr. Neufeld.
Thank you. Morning, ladies and gentlemen. Hi. One moment. Ms. Clark asked you a series of questions this morning about your several trips you made out here during the last month. You recall those questions?
Yes, I do.
Did you make several trips out here during the last month because you had been told you were going to testify, and then because of scheduling problems, you then had to go home and return again, and go home and return again?
That's correct.
One moment. Your Honor, before I continue this redirect, can I have a brief sidebar?
With the court
Thank
reporter,
you.
please. All right, thank you, counsel. Mr. Neufeld?
Thank you. What I would like you to do, Professor MacDonell, for most of these questions is use the same terminology that prosecutor used, namely, we have side 1, side 2, side 3, and side 4 of the socks. And could you just quickly show, perhaps using your own sock again, what we mean by that with side 1, side 2, and side 3, and side 4?
I use my sleeve instead.
Fine.
If the stain is on the top, that is considered side 1. Side 2 would be inside where liquid could soak through. Side 3 would be opposite if the garment were lying flat, and side 4 would be the outside, which would be opposite the side 3.
Thank you. Now, on cross-examination, the prosecutor asked you a series of questions concerning the manner in which the socks had been handled prior to your examination on April 2nd. Do you recall her asking you those questions?
Yes, I do.
And do you recall her in those series of questions asking you whether, for instance, if the socks were twisted in a certain way, could that produce the red balls that you observed on surface 3? Do you recall her asking you that question?
Yes.
All right. Professor MacDonald, in your opinion, could twisting the socks result in producing the red balls that look like blood bonded to the fiber on surface 3?
No, it could not.
Why not?
You can't create little round balls of fluid that dry on a fiber by simply twisting a garment. You can't do it.
Professor MacDonald, could freezing and thawing the sock in the laboratory's freezer after the stains had already dried produce the red balls that look like blood bonded to the fiber of surface 3?
No, they could not.
Why not?
There would have to be a substantial amount of moisture, and that would show up by diluting and diffusing